Hello, this presentation is brought to you by Jimerson Cobb, PA. The title of this presentation is Actions for Breach of Real Estate Sales Contracts. Your narrator is Wahl, an attorney with Jimerson Cobb, and this presentation is as of June 6, 2014. The roadmap for this presentation is as follows. First, we'll do a brief introduction and provide the scope of this presentation. From there, we'll give a general overview of the action. We will discuss specifically action by seller for damages and action by buyer for damages. We will also discuss actions for specific performance, which is a remedy available to either the buyer or the seller. As we close this presentation, we'll discuss the drafting of complaints and responses to complaints, and then we'll conclude by going over a checklist of things that you should look for in a real estate sales contract for drafting the complaint and or a counter complaint. Now, the real estate sales contract will establish the rights and the obligations of both the buyer and the seller with respect to the underlying real estate transaction. As far as the scope of this presentation goes, I will discuss the actions by either the buyer or the seller when one of the parties to the real estate sales contract breaches it by failing to perform an obligation. The topics that will be included will have a discussion on the statute of frauds, liquidated damages, lis pendens, the measure of damages available to the seller when the buyer breaches, and the measure of damages available to the buyer when the seller breaches. We'll also discuss the seller's disclosure obligations when it comes to real estate transactions, and the remedy of specific performance, which again is available to both the buyer and the seller. And we'll also go over the checklist for complaint preparation and drafting. Now, as far as a general overview of the action, the first thing that we must determine is whether or not the contract is enforceable. And with that, we turn to the statute of frauds. The statute of frauds is contained within section 725.01 of the Florida statutes. And it provides that among several other types of contracts, a contract for the sale of real property must be in writing and must also be signed by the party to be charged. Now, that's not all. Case law will also provides that to be enforceable, a written contract for the sale of land must also be certain as to 1, the parties involved, 2, the subject matter, 3, the promises made by both sides, and 4, the consideration. And there is an exception to the statute of frauds for oral contracts or faulty written contracts. So there can be some situations where a normally unenforceable contract is taken out of the statute of frauds and becomes enforceable. But things to keep in mind here, there is no exception to the statute of frauds for actions at law, which that would be for actions seeking money damages. But there are exceptions to the statute of frauds for actions in equity, which would be actions for specific performance. And this exception to the statute of frauds is a doctrine called part performance. Now, this is a response to the statute of frauds defense that will remove the bar of the statute of frauds and provide relief in equity for the buyer. The way this works is that to enforce an oral contract under a part performance defense, the contract must be established by clear, definite, and certain proof. Now, that would be established through admissions during the litigation. It could be either admissions obtained through a deposition or through written admissions. Additionally, the buyer must prove the following elements for part performance. 1, that he or she has paid all or part of the consideration. 2, that he or she has possession of the property. And 3, that he or she has made valuable and permanent improvements. The catch-all here is that or there are such facts that exist that would make the transaction a fraud on the buyer if the contract is not enforced. We will now discuss liquidated damages. Now, a liquidated damages clause, which will oftentimes exist in a real estate sales contract, this is where the parties to the real estate sales contract will either limit the available remedies or include a certain amount that is to be awarded as damages. Now, to be enforceable, the liquidated damages clause must attempt to reasonably approximate fair compensation for the non-breaching party. Conversely, if the liquidated damages clause is deemed to be a penalty or unconscionable in nature, then that clause will not be enforced by the court. A liquidated damages clause is also unenforceable if it provides for a unilateral election of remedies for one party, or if it eliminates the mutuality of the parties' obligations. In the case of Ropeza v. Reyes, the liquidated damages clause at issue provided the seller with three options to choose from. It could either retain the buyer's deposit, or the seller could bring an action in equity or an action at law. The court held that providing the seller with a range of alternatives made it unenforceable because the seller had the unilateral election of remedies while the buyer did not. In the case mentioned in the second bullet point, it involved the same situation. The liquidated damages clause gave the seller the option to sue or to retain the security deposit, and the court again held that it was unenforceable, but here it stated that it negated the intent to liquidate damages in the first place, and therefore could only be construed as a penalty. In the case of Hackett v. JRL Development, the liquidated damages provision, it limited the buyer's remedy to merely a return of his or her security deposit, while at the same time it gave the seller a choice of remedies, and the court held there that that was unenforceable because it eliminated the mutuality of the parties' obligations. Now, lis pendens, that is a document that must be filed and recorded simultaneously with the filing of the complaint. By filing a lis pendens, what that does is it places the public on notice of pending litigation involving a certain piece of property, and it informs the public that any interest that is acquired after its filing is subject to the decree of the court from the underlying litigation. Now, before a proceeding can encumber any real property, the lis pendens must be filed and recorded in the office of the clerk of the circuit court of the county where the property is located. If the lawsuit against real property is not predicated on a recorded instrument, then on proper motion from the opposing party, the court can condition continuance of the lis pendens on the posting of an adequate bond. For example, a deed is a recorded instrument, so is a mortgage. So if a claim is brought based on the mortgage or the deed, then it's on a recorded instrument. But there may be an issue involving some form of adverse possession where there is no underlying recorded instrument that is the basis of the action. Well, in that case, the court can require a bond, and the amount of the bond would depend on the potential loss or damage likely to be incurred if the lis pendens is not justified. And in that situation, the defendant would not need to show irreparable harm. It would be entitled to move the court for a requirement of posting an adequate bond regardless of a showing of irreparable harm. And when it comes to a challenge of the lis pendens, the burden would be on the plaintiff to show a fair nexus between the apparent legal or equitable ownership of the property and the dispute embodied in the lawsuit. Now, to be valid, the section 48.231 of the Florida statutes provides for what is required in a lis pendens. And to be valid, the notice of lis pendens should contain the following. It should name the parties. It should name the date of the institution of the underlying action. It should also provide the name of the court in which the case is pending. It should provide a description of the property involved, and also a statement as to the relief sought as to the property. Okay, now we'll transition to actions by the seller for damages. First, if there is an enforceable liquidated damages clause within the contract, then it will control. But if the buyer breaches a real estate sales contract and there is no enforceable liquidated damages clause, then the seller will have two alternative remedies available. The seller can retain the property and sue the buyer for monetary damages, or the seller can sue to compel specific performance by transferring the property to the buyer and recovering the purchase price plus any incidental damages involved in doing so. And this brings us to the seller's measure of damages. So the seller can sue for monetary damages, but how do we measure those damages? If the seller decides to retain the property and sue for damages under breach of contract, the measure of those damages would be the difference between the agreed upon purchase price in the contract and the fair market value of the property at the time of the breach. It would also be reduced by any money that was already paid by the buyer. What that means is there is the possibility that there could be no damages. For example, if the sales contract price was $59,000, but at the time of the breach, during the litigation, the seller testifies that at that time of the breach, the value was the same, or $59,000, for example, then the damages would be zero because the difference between the contract price and the price at the time of the breach was zero. But the seller may also recover other damages if they were reasonably within the contemplation of both parties at the time of contracting, and if they arise as the natural and proximate cause of the breach. And an example would be incidental costs. Let's say the seller had to move or relocate, and due to the breach by the buyer, the seller had to undo that transaction. That would be an incidental cost recoverable by the seller. Now, on the other side of the equation, we'll discuss the actions by the buyer for damages. And again, if there is an enforceable liquidated damages clause within the contract, then it will control, and that amount will be the damage amount awarded by the court. But if the seller breaches the contract and there is no enforceable liquidated damages clause, then the buyer will have differing legal and equitable remedies available. If the seller is able to convey title to the property, then the buyer may seek specific performance. But sometimes the breach is due to the seller not having title in the first place, which would make that remedy unavailable. The buyer may also bring an action at law for monetary damages in that situation. This would be a good time to discuss the seller's disclosure obligations when it comes to conveying property. And concerning a seller's breach, the seller's breach could result from not disclosing something that the seller should have disclosed. Now, a latent defect, this is a defect that is not readily observable or known to the buyer. And if the seller knows of conditions materially affecting the value of property that are not readily observable or known to the buyer, the seller has a duty to disclose those conditions to the buyer, and that was the holding in the case of Johnson v. Davis. And that disclosure obligation applies to both new and used residential properties. And the disclosure obligation cannot be avoided by including a broad as-is clause in the real property sales contract. So the seller can't draft the contract and include a broad as-is clause and then use that to say that the seller was no longer obligated to disclose latent defects. But the seller can be relieved of this disclosure obligation if the disclosure duty is expressly stated and waived by the buyer in the sales contract. Now, concerning commercial property, the general rule here is caveat emptor, buyer beware. This doctrine applies to the sale of commercial property. So what this means is the mere non-disclosure of a material fact unaccompanied by words or acts sufficient to constitute act of concealment is not actionable. But a seller of commercial real estate can be held liable for harm caused by material representation, act of concealment, or other scheme for creating a false impression. So there isn't a duty to disclose. The mere non-disclosure is not actionable regarding the sale of commercial property. But if the seller performs some act that could be construed as act of concealment or creating a false impression of what the property looks like, then that can be actionable. All right, now if the buyer is seeking monetary damages as a remedy, now this would be the buyer's measure of damages. And the measure of damages would depend on, one, whether the seller acted in good faith when he breached, or whether the property has been sold to a subsequent buyer. The court has developed what it referred to as the out-of-pocket rule. If the seller's breach is in good faith and the property has not been resold, then the buyer's measure of damages is the amount of money paid, which would be the deposit, together with interest and any other compensatory damages such as title search or moving expenses. Now, if the buyer was already in possession of the property when the seller breached, the buyer's damages may be offset by a reasonable rental value for the period of the buyer's occupation of the property. So that would be a set-off for the seller. Okay, now continuing with the buyer's measure of damages. Now, if the seller's breach was in bad faith, but the property has not yet been transferred to a subsequent buyer, the buyer may obtain the difference between the contract price and the value of the property on closing date. But again, that damage amount may be zero depending upon the market and the direction of housing prices at that time. Now, whether a seller acts in good faith or bad faith is a question of intent. For example, if the seller thinks he is relocating because his employer gave him reason to believe that, but then at the last minute that fell through, if the seller had already entered into a real estate sales contract because he believed he was relocating, well, the seller ended that contract in good faith. He still breached it, but he was not acting in bad faith. The court has provided certain instances which, if they exist, would show that the seller did act in bad faith. These situations involve, one, when the seller knew or should have known that he or she would not be able to comply with the contractual obligation. Two, when the seller just simply refuses to convey title. Or three, when the seller enters into the contract without title of the property, but expects that title will be acquired, but then fails to acquire title. In that situation, the seller is deemed to have acted in bad faith. And finally, regarding the buyer's measure of damages, there is the benefit of the bargain rule. And this is when the seller's breach was followed by a sale of the property to a subsequent purchaser. If this is the situation, so this would be where buyer number one enters into a contract with the seller, and then a week, a month, 2 months later, buyer number two comes around and the seller decides to now sell that property to buyer number two. Determining the seller's intent, whether it was good or bad faith, is irrelevant, because in that situation, the proper measure of damages will be the return of any purchase money paid by the first buyer, plus interest, plus special damages, and any of the profit that the seller made on the subsequent sale. The economic loss rule. This doctrine has a long history in Florida law. In 2013, there were some changes to this doctrine as it could relate to the real estate sales contracts. Prior to 2013, if the buyer's cause of action was based on an economic loss from latent defects, the buyer's recovery was limited by the economic loss rule, which means a tort action would have been prohibited if the parties had a contractual relationship and the only damages suffered were economic losses arising from the breach of that contract. So, in essence, the economic loss rule was seen as the boundary between contract law, where the court is to enforce the parties' expectations under the contract, and tort law, where the court would be enforcing the duty of reasonable care. In 2013, the case of Tierra Condominium Association versus Marsh and McClellan Companies, in that case, the plaintiff had causes of action against the defendant, who was an insurance company. Those causes of action were negligence, which is a tort, and breach of the contract. In the court's holding, it limited the economic loss rule to product liability actions, meaning that it doesn't apply the same any longer into real estate sales contract actions. Now, although it limited application of the economic loss rule to product liability cases only, in the concurring opinion, it was stated that if a party is going to bring a valid claim in tort, it still must show that the tort is distinguishable from or independent of the breach of contract action. In other words, if the only action that you're suing a person under is the action that breached the contract, well, then that's a breach of contract action. It's not a tort action. The way this would play out is if that is the only act is a breach of contract, and the contract had a liquidated damages clause, then you couldn't bring a tort cause of action in order to circumvent that contractual remedy agreed to by both parties. Now, that is how the concurring opinion was structured. This has yet to play out in an appellate court since that 2013 decision in Tierra Condominium Association. Now, this will take us to the remedy of specific performance. Specific performance is a remedy that seeks the specific enforcement of transferring ownership of the subject property as contracted for in the underlying sales contract. Now, this remedy is available to either the buyer or the seller. However, the remedy of specific performance is not available unless the contract terms, such as the parties' obligations, the time and method of performance, unless those terms are clear, definite, and certain in the underlying contract. If they're not, then specific performance is not available as a remedy. And to enforce this remedy, the complaint and or counterclaims must also include a sufficient description of the property involved. And that's pretty obvious, because if you're seeking to have the contract enforced so as that the property is transferred, then you'll need to sufficiently describe the property that you want transferred. Specific performance may even be granted under an oral contract for the sale of real property, but only in the limited instance where the buyer is already in possession of the property at the time of commencement of the action. So keep in mind that specific performance is discretionary with the court, and it's not a matter of right. It's just like any other remedy. Thus, the court may deny the remedy even when the terms of the contract are clear and unambiguous and the remedy is available. So the bottom line is it may be available but still not awarded. In fact, in one case, it has been held that the court should not grant specific performance if an adequate remedy exists at law. However, in this case, Vagabond Travel and Tours versus Universal Inns of America, that involved the renting of hotel rooms and the breach of the hotel when it was determined that the Super Bowl was going to be held in the city. The court held that the specific hotel rooms were not unique, and therefore specific performance was not available, and the only remedy available to the plaintiff was monetary damages for the cost incurred in having to relocate and find replacement hotel rooms. Now, there are some instances where documents involved in real estate transactions involve witnessing requirements. The Section 689.01 of the Florida statute states that no real estate shall be transferred without an instrument in writing signed in the presence of two subscribing witnesses. Now, The statute actually only applies to deeds because a deed would be the transferring instrument. It would not apply to the underlying sales contract because the underlying sales contract is not the transferring instrument. It's merely the contract that the parties enter into. But the deed at closing would be the instrument that actually transfers the property. So real property sales contracts do not have to be signed by witnesses, but the deed transferring the property would have to be signed by witnesses. In 1957, there was the case Jimerson versus Diedrich, where the court held that a contract to convey homestead property must be signed by both the husband and the wife in the presence of two subscribing witnesses. But there was a subsequent Florida Supreme Court case 20 years later that held that a mortgage involving homestead property did not need to be signed in the presence of two subscribing witnesses. Well, a mortgage is a form of contract, so it may seem a little conflicting, but since 1978, there have been at least two DCA District Court of Appeal cases that held that a contract to convey homestead property need not be signed in the presence of two subscribing witnesses. So those DCA courts treated the 1978 case as overturning that 1957 case, although the Florida Supreme Court did not expressly state that. And since that time, this Florida Supreme Court has yet to rule on whether the Moxley case did in fact overrule the Jimerson case. As we move to conclude this presentation, I want to first discuss some general info and tips for drafting complaints, answers, and counterclaims. Now, under the Florida Rules of Civil Procedure, a party is able to plead as many separate claims or defenses as are available, and it doesn't matter if those claims and defenses are consistent with each other. They can be both legal and equitable in nature. And a party cannot be required to elect before trial the claims or defenses on which the party intends to rely. So if there are inconsistent remedies or inconsistent claims, the party is not required to elect before trial what claims it tends to rely on, but it must do so before judgment is entered. So the plaintiff and or defendant may proceed through the trial on inconsistent counts and defenses, and such inconsistent counts and defenses could be rescission, reformation, specific performance, or money damages. For example, you could be seeking specific performance, which is the turnover of the property, or money damages, which would mean in lieu of that, just the damages that you incurred. Well, on the issue of liability, if you win, you don't have to make a determination as to what remedy you wish to move forward with until the time for judgment being entered. Concerning affirmative defenses to a claim for breach of real estate sales contract, the most common are failure of consideration, statute of frauds, estoppel, fraud, waiver, and payment. Now, in closing, here is a checklist for items to look for when reviewing a real estate sales contract prior to drafting a complaint or a counterclaim or an answer and affirmative defenses. Some things that you should look for. First is review the underlying contract for the identity of the parties, for proper spelling and to ensure that you are including all parties who need to be included. You'll also want to review to see if does the contract provide for a notice and a right to cure the default prior to instituting a lawsuit or declaring a default. If so, you want to ensure that you're doing such things, or else the lawsuit could be dismissed for not complying with all the conditions precedent. And regarding jurisdiction, there may be a clause in the underlying contract that where the parties have consented to a certain jurisdiction or venue, and may have even contractually appointed an agent for service of process. And deposits. The contract may state that certain amounts were already paid as a deposit, and that would be important for when it comes to determining outstanding damages that you are seeking in the lawsuit. Now, you'll also want to review the contract to see if there's an escrow agent, because depending upon the issues involved, the escrow agent may need to be included as a party to the lawsuit. And you'll want to see if there's any conditions. There may be some conditions precedent in the contract, and you will first need to determine whether they have been met or waived by the parties involved. And the time and place of closing may be important. It may affect venue or the choice of law involved. And you'll also want to review the contract to see if there are any formalities of execution provided, because that could affect the enforceability of that contract if the formalities were not complied with. And you'll also want to see if the contract provides for attorney's fees, because if it does, you'll want to make sure you include that in your prayer for relief in the complaint and/or counterclaim. You will also want to see if there is any limitation of remedies in the underlying contract. For example, the contract may actually include a provision that excludes specific performance as a remedy. There may also be a liquidated damages clause, and if there is, as mentioned earlier in this presentation, you'll want to check for enforceability under Florida law. And a few miscellaneous provisions to look for in the contract is there any time of the essence provisions? Is there an arbitration clause? Is there a waiver of jury trial? Is there a limitation on survivability of covenants or representations and warranties? Is there an integration clause for collateral or side agreements? And is there a provision stating that all amendments or modifications must be in writing? Well, that concludes our presentation today, and on behalf of Jimerson and Cobb, I would like to thank you for your time.